Hello all. Hello.
Hello.
Am I audible?
Yes.
Okay, so we are starting this the webinar. I want to begin by thanking everyone who has joined till now and those who will join later on this webinar on citizenship law and related issues in India. My name is Ravi Himadri and I work with Development and Justice Initiative as its director. My organization works with refugees, migrants, and minority populations and people at risk of statelessness. I am a member of the Right to Nationality and Citizenship Network. Thank you again to everyone for joining this webinar. This is the first webinar being organized by the Right to Nationality and Citizenship Network, and we hope to engage here with issues of citizenship, discrimination against minorities, and the risk of statelessness in India. The network aims to, this network was formed recently last year. We started a process of bringing together everyone because we thought that it is important for all of those who are concerned with these issues in India to come together. And we aim to, through the network, we aim to campaign and advocate for the right to nationality for all Indians. We aim to mobilize public opinion to challenge arbitrary deprivation of citizenship in India, challenge the citizenship verification processes in India through documentation and research, and we aim to connect with global campaigns and movements to end statelessness. In today's webinar, we have an impressive panel of speakers. Let me briefly introduce them. We will have firstly Anjuman Begum will firstly speak, and she's a human rights researcher from the northeast of India, of which Assam is one of the states. Her major contribution is on issues of impunity in the region. She has done documentation of victims' experiences, their narratives, and legal analysis. And her publications include state accountability through victims' perspective. Anjuman is also a freelance journalist and is a member of network of human rights women human rights defenders in India. Then we will have Sanjay Hegde, who is a reputed senior advocate at the Supreme Court of India, and he specializes in different fields of law, including citizenship. He has represented people declared foreigners by foreigners tribunals in Assam and written about the issue of foreigners and the Supreme Court's handling of the NRC process. He has worked as a senior advocate since 2015 and appeared before the Supreme Court in several high profile matters. He is a leading voice for civil rights and supports dissent against suppression of dissent by authoritarian regimes. Aman Wadood will be joining. He's not here at the moment. He's a human rights lawyer based in Assam who defends citizens charged as foreigners. He works very extensively with the foreigner tribunals, represents many cases across different foreigner tribunals in Assam, and also takes up cases at the High Court level and has. And also at the Supreme Court level, he has taken up a couple of cases. In fact, one of the cases where after the COVID detainees were released, of detainees who had completed 2 years of detention were released was done by him at the Supreme Court. Then we will have Amal Di Chikera. Amal is the co-director and co-founder of the Institute on Statelessness and Inclusion based in the Netherlands. He also teaches a master's level course on statelessness and right to nationality at Middlesex University, London. Amal has researched, advocated, written, spoken, delivering trainings, and served as an expert on statelessness and related issues for the UN, NGOs, academia since 2008. Now, then we will have Anshuman Chaudhary, and when he speaks, we will be also releasing our report, which we have done on COVID and its impact on people at the risk of statelessness in Assam and what hardships and exclusion they suffered. Anshuman is a senior researcher at the Institute of Peace and Conflict Studies in New Delhi, and a former visiting fellow at the German Institute of International and Security Affairs, Berlin. He works on issues of armed conflict, peace processes, forced displacement, and citizenship. He is also a founding editor of an 11th column and an online magazine on politics, foreign policy, society, and culture. And I'm Ravi Himadri. I will be doing the coordination. I'll be doing the coordinating all the speakers. And as speakers go on, I will be also taking my notes. And maybe briefly after um each presentation is over, I will briefly uh, highlight the points which have been made in the presentation. So, and there will be for all the attendees who are there, there will be a Q&A. So through the Q&A, you will have to put in your questions to the panelists, and at the end of all the presentations, we will have the panelists will address all the comments and questions and observations, or whatever else that the attendees will post on the Q&A section on this website. So that is it. That is as far as logistics is concerned. Uh, so we are ready to go. We will have Anjuman, who will be speaking mainly from her experiences of documenting in documentation she has done in Assam, and she has a presentation, and she will be using the presentation of several cases she has studies she has done in Assam. So over to you, Anjuman.
Thank you, Ravi. I hope I'm audible. Yeah, thank you, and very happy to join this webinar, and also to be a part of this network that addressing the very important issue right now that we are passing through, the citizenship rights. So I thought that since this is a discussion, focused on the broader issues of citizenship rights, and I wanted to share some of the cases that I documented last year during COVID times. And just to give an idea that the kind of hardship, the prejudice, and the financial harassment that the people face while going through this process of detection of who is a foreigner or who is an Indian. So I would request Anshuman to help me with scrolling down the presentation. So if we can have the first picture.
Yeah, I think Alina has control of it.
Okay. Yeah. So this picture you can see a man and his son, and on the extreme right is one of my friend who was accompanying me during this visit. His name is Azbahar. He is about 67 years old, and briefly his case is that he was being suspected as a foreigner, and there was a case pending, and he was regularly attending that case, and he was presenting his papers and everything. And then in one day, while waiting for his for the hearing of his case, the police came and said that he has been already declared as a foreigner by another tribunal, and he has no clue that there's another case going on against him in another foreigners tribunal. So he was arrested and he was taken in a detention camp, and his family was also not informed, but later on they came to know, and they filed a case in the Guwahati High Court to prove that he is an Indian, and it caused a lot of financial hardship to the family. He was the main earning member in the family of five members. And then in the High Court also, he was declared as a foreigner, and the family was asked to appeal in the Supreme Court. And it was extremely difficult for them because whatever the resources, financial resources they had already exhausted by that time. And when his wife came to know that they have to now approach the Supreme Court, she became very depressed, and then in the same night she committed suicide in the early morning. And so her suicide created another crisis in the family, and still the family tried to file a case in the Supreme Court, but it's pending now, and one NGO, students NGO, is helping them financially, and a pro bono lawyer is also helping them. And he has been out of the detention camp now after 3.5 years, and like he's very weak physically and also mentally, and sometimes he's not able to speak, and he even forgets that he has not eaten. So this is the situation right now, and they are passing through a very extremely financial crisis, including after the COVID and lockdown, which had another impact. And and we can say that a very happy and prosperous family is finally now completely devastated. So this person I met in last year in July. Yeah, the second one, she is Roshia Begum. She was from Meghalaya, the current Meghalaya state. Meghalaya was earlier a part of Assam state, but in 1972 it became a separate state. So she is about 40 years old now, and she was married off at the age of 12, and with a man from Assam. This Assam Meghalaya border is, very close, and it's not that far. Her husband's house is also not that far, and she doesn't have papers to prove the linkage with her father. So that was the main reason that she was declared a foreigner, and she also spent more than 3 years in the detention camp, and still she also had the similar physical weakness, and also mental depression. And you can see one of his son is with her, and in this picture she has three sons, and all of them dropped schooling when she was detained and taken away from the family. So she is now suffering from, like I said, weakness, also eyesight. I mean, most of the this people, detainees that I have interviewed, all of them has complained of loss of eyesight or reduced vision after the detention. Can I go to the next one? No, this is the previous one, just the last one. Yeah, little below. Yeah. Thank you. This person is also from near Assam Meghalaya border. And what happened with him? His name is Nazrul. He was also in the detention camp in Kokrajhar for more than 3 years. And so what happened, like when he was declared as a foreigner, he panicked, and he contacted the local leader or people who makes documents, government documents like birthday certificate and other certificates. So he contacted them and asked them to get his birth certificate. But what happened? The person made a fake birthday certificate, gave it to him, and took money. And then in the court, it was proved that his birth certificate is fake. And also, as per the legal proceeding, a birth certificate issued after 3 months of birth is not considered a proper birth certificate. It's not admissible in the court. So based on that, the fake birth certificate, he was declared a foreigner, and he spent about 3 years in the detention camp, and now he is He's out, but he used to work as a migrant worker in the construction site. But now, because of the weakness and low eye vision, he is not able to work. Can I have the next one, please? Yeah, and this one, another case. She is the wife of a tribal person. His name is Noresh Koch. Koch community is recognized, as one of the indigenous community here in Assam. And he was, both of them used to work in a fishery project. So they were working there for 2 years. And Noresh used to go to the local this country liquor shop and used to drink there. So he was there when police came and said that he has been declared as a foreigner. And they had no phone, and also his wife didn't know about this, that he has been already taken away. And then after 2 3 days she came to know of this, and but she has no money. And then police gave her money to go and visit her husband in a detention camp. The detention camp was in Gwalpara, so it is about 40 kilometers away from where she was living. And and that time she met her once, and after that Noresh Coates was in detention for nearly 2 years, but she could not, collect money and could not meet him. And then police visited her again after 2 years and gave her money to go to Guwahati Medical College Hospital to visit her husband. So that time she met her husband again, and but he already had some stroke during the detention, and after a week he died. And this case was really, it attracted made a big public outcry because the person was indigenous and also declared as a foreigner. And well, he had no clue, and he has been living there for since birth, and literally it appears that there's a big mistake, and he has been deprived of his rights, and ultimately he has to die in detention camp. And the next one, this case, when I documented this case, I was very depressed, and it's like her name is Momira Nisa, and she was in detention camp for more than 10 years. I think 10 years and 6 months or 3 months. Sorry, 3 months. And you can see the one boy next to her in this picture. He was about 3 years old when she went to the detention camp, and when she returned, he was this big, nearly 13 years old. And one thing I found in this case is also same. Like she could not prove her linkage with her parents, and also then I realized that why she could not prove, because both of her parents are alive, and they are about her mother is about 90 years old, and her father is also of the same age, and it could have been easily proved whether she, through DNA test, whether she has linkage with her father or not. But DNA test is not acceptable mode of proof of linkage. Uh, so you can understand the hardship here. And also when she was in detention, she told me that she was pregnant for 3 4 months and she had an abortion. And also her husband died of depression while her detention was ongoing. So now she's out on bail after the Supreme Court ruling, and but still it's very uncertain, like what is going to happen with her case and whether she will be able to lead a normal life again. And also one thing very important here is that she and her family has faced a lot of internal displacement. I think about 10 or 11 times they have shifted their house. They live in very flood prone area, and also the river erosion has affected their uh, their residence. They have to change it a lot of time. Yeah, the next one. Yeah, and this also, I met them in September last year, and three of them were there. And the issue with them is that they were second wives with their husband, and their name was not included as wife in the official document. So neither from their parents' side they have any document to prove that, or from her husband's side as well. And during this COVID time and lockdown time, they have been served notice by the Foreigners Tribunal. And the problem they were facing is that since they were declared as doubtful voters long back, the officials are denying them to procure other documents for them, or documents that belongs to their relatives or family members. So yeah, so these are some. I want to conclude, but these are some of the cases that I wanted to show you, which really depicts the system and how it is impacting them. The detention camps literally means prolonged captivity and nothing else. So I feel that the fairness and due process of law, which is guaranteed in our constitution under Article 21, and it's available to all person, not only citizen. These are completely absent here in these cases. And also the cases that I have documented so far, most of them are financially weak from marginalized community and also from the linguistic and religious minority groups. So we can say there is targeting racial targeting of a community here. And then the rule of law, of course, and also legal aid is completely missing. None of these cases or the families could access any free legal aid, which is also provided in our constitution, but it is not there. And also gender discrimination, like in CEDAW, it's already clearly says that gender discrimination has a broader definition there, and India is a party to it. But despite that, and also even if we check our constitution, there has been glaring gender discrimination in this process. And in NRC process, as we know, majority of those excluded are either women or children. And also, like I said, the majority of the cases that I have studied, people are victims of internal displacement, either for climate change or for violent conflict, especially ethnic conflict. And also, I feel that the international community has not so far responded to this issue, where the creation of statelessness is going on, and it's more engagement is required. Human Rights Watch or Amnesty International, they published a report on this only recently, but this process has been going on for a long time. Uh, and also especially the marginalization, which started, in my opinion, since 1983, where Nelly massacre was commemorated, some sort of established impunity for all these, wrongs, and that is, targeted towards this community. And and of course, I feel that this understanding of suspected foreigner is also very colonial, and just unlike APSPA, Armed Forces Special Power Act, which is a law in Northeast India that gives sweeping power to army to kill anyone. So this foreigners tribunal law is also some sort of similar. It depends heavily on the word suspicion. Like you can just suspect someone as foreigner, and you can force them to go through all these hurdles. The same thing that happens under Armed Forces Special Power Act as well. Like someone can be killed if they are suspected as as a militant. Yeah, and also lastly, like it has been already reflected what Ravi said, that there's a growing international effort to reduce statelessness, but in Assam it's been creating people is a creation of statelessness, and with the sanction from the state, from judiciary, from society, and literally from all. So this is my brief presentation. I hope I could manage within the time. And if there is a question and all, I'd like to take up that later. Thank you. Thank you all.
Thank you, Anjuman. I think your presentation is fairly comprehensive on what kind of people are targeted as foreigners, and the detention issues and the issue of internal displacement in Assam. So I will not go into any more points on what you have presented. I will straight away ask Sanjay Hegde to speak from his experience and his knowledge of law. I mean, hearing what Anjuman has presented just now and from his own experience. So Sanjay, over to you.
Thank you, Ravi. Anjuman has presented a few cases of people who've been caught in the process. The one common thread that runs through all these people is simply this, that they are among the poor, and the poor are unable to document what has happened with regard to their ancestors. Now, I would first like to take all of you all through the history of Assam itself, which has a bearing on this particular conflict. Now, this particular conflict arises primarily out of confusing nativism, ethnicity with citizenship. The unstated, inarticulate major premise of this entire process is that Assam is for the Assamese, that is for the Assamese speaking Hindu or Muslim, and that anybody who does not fit in within that definition is quite necessarily a citizen of the neighboring state, the neighboring country of Bangladesh. Now, India was divided into India and Pakistan in 1948. East Bengal was East Pakistan. That was next to the state of Assam. But there is a certain pre-colonial history that all I must advert. What basically happened was that the areas that comprise the Brahmaputra Valley came under British control after the Burmese lost control over there. They were added to the erstwhile state of East Bengal after the partition of Bengal, and there was a time for about a decade or so that the areas that comprise modern day Assam were ruled from Dhaka. Now, as independence came and as partition came, there was a religion-denominated partition, religious and a linguistic partition. So necessarily, it was assumed that most people who spoke Bengali and who were Muslim were Bangladesh. However, that's not how it actually worked out on the ground with actual people. The people continued to live where they were, and boundaries and nations around them changed. So you could be living about 10 kilometers from your grandfather, and then a line which was drawn on a map, which became a new nation. You continue to meet your grandfather. Your grandfathers came and met you. The things were not frozen in time. Nationalities were not frozen in time at that particular point of time. And a lot of poor never maintained documents, nor could they reasonably be expected to. The politics of Assam at that stage had two or three very famous people, including one gentleman who was a member of the Constituent Assembly from Assam, Mohammad Sadullah, who had earlier been chief minister. You had Gopinath Bordoloi, who was his one-time friend with whom they had played tennis together. At that point of time, there was a feeling that Sadullah necessarily encouraged a lot of migration from the lower province of what was previously one conjoint India, that is from the Bengali-speaking areas, into the areas where the Assamese speakers had a majority. That process was seen to be continuing over the period between 1947 and 1971. Around, from the late 1960s onwards, there were problems in the old East Pakistan, which is now Bangladesh. There was mass scale migration, and there was migration also into Assam, into Bengal, and into various states in India. It was in 1978, in the Lok Sabha the elections to parliament from one constituency in Assam, that the ethnic Assamese populace felt that they were being outnumbered by waves of migrants. That started off the Assam agitation. The Assam agitation ended up in the Assam Accord between the Prime Minister of India and the All Assam Students Union, which basically said that all migrants post 1971 would go back to Bangladesh in accordance with what had been agreed between Prime Ministers Indira Gandhi and Mujibur Rahman. But pre-71, from 66 onwards, they would be disenfranchised for a particular period of time, for 10 years, and thereafter they would continue to be full citizens. Now, it was in this historical framework that the interstate migrants determination tribunals were set up, that illegal migrants determination tribunals, sorry, IMDTs as they were called, which were tasked with finding out who was an illegal migrant. So people could go and complain that so-and-so was an illegal migrant, and they had to prove that case against that person, and that person would then necessarily be asked to leave. We also had, in 1948, a particular, in 1946, before independence, there was another act which was passed, which was called the Foreigners Act. Now, the Foreigners Act was basically to deal with what British India perceived as recognizable foreigners. There was a fear of Japanese infiltration in the Northeast. There was a fear of Germans coming in after the World War, or around the World War. So they wanted a procedure by which a known foreigner could be identified, taken before a tribunal, detained by the authorities, and then sent back to the country of origin. Now, the illegal migrants determination tribunals continued from 1985 onwards till the mid-2000s, when they were struck down by the Supreme Court in a case called Sarbananda Sonowal, filed by the person who is currently the Chief Minister of Assam. When the Illegal Migrants Determination Tribunal Act was held to be unconstitutional and struck down, no alternative mechanism was brought into place. What happened was that the states then fell back upon the Foreigners Tribunal, which was a pre-constitutional enactment of British India, and the procedures laid therein were suddenly applied to a large mass of poor, undocumented people. There's a section in the in the Foreigners Act, which says that the burden of proof of establishing that the person alleged to be a foreigner was not a foreigner fell upon that person. So the burden of proof had been reversed. In exceptional cases for foreigners, that was what was originally. But now it came to be wholly applied to huge masses of poor undocumented Indians. Now, if the same procedure had been applied, is applied to any mass of poor Indians, you will have the same kind of large numbers of people who are unable to prove by documentary evidence that yes, that their ancestors were born in India, and hence they fully complied with the provisions of being granted citizenship by birth. So if you go into an ordinary poor area in any of the metropolitan cities and ask people out there, show me proof that your grandfather was indeed living in India in the years before 1971, I would dare say that a majority of people would fail that test. But that is the kind of test which has been applied in Assam in respect of these foreigners' tribunals. So the entire process before the tribunals is that can you prove by documentary evidence that your ancestor was indeed there in India? So people go to find out the voting lists of 1971 or 1966 and say, my grandfather was so and so. And from him I can prove by a birth certificate that my father or my mother was this, and so on and so forth. But these tribunals are manned by people who do not have constitutional protection, who are there on contract, and who seem to act on an informal directive not to accept claims of citizenship by people alleged to be foreigners. So almost every document that is produced, there is some fault found for some reason or the other, and they say that you have failed to prove that you are an Indian citizen. My simple question is that a poor man may fail to prove that he's an Indian citizen, but that does not ipso facto make him the citizen of any other country. And this is where the real problem of statelessness comes in. You have people who are declared by a somewhat suspect, a dubious legal process to being declared as not being able to prove Indian citizenship, but you have no other country which claims them as citizens, nor is there any proof which actually links them to some ancestor in the other country. So what is the consequence? The consequence is that these people who are declared to be non-Indian citizens are detained, and that detention becomes indefinite. There is no process whereby somebody who's been declared not to be an Indian citizen can be let out back into freedom with possibly a loss of voting and other rights, but nevertheless with an ability to take care of himself or herself and their families. So India ends up unnecessarily detaining people indefinitely for failing to prove by documentary evidence that their grandfathers or other ancestors were indeed Indian citizens. This is a situation which cannot indefinitely continue. I've been asked to speak about what happens in the judicial process further up. There is no appellate forum as far as the foreigners' tribunals are concerned. So for want of an appellate forum, people necessarily have to approach the constitutional courts. A constitutional court is the High Court or the Supreme Court. By definition, constitutional courts do not necessarily reappreciate evidence. So unless there is a great glaring error, most high courts, the High Court of Guwahati has often said, no, this is not something that we can interfere with in our writ jurisdiction. From there, those few people who attempt to come to the Supreme Court face another burden. The Supreme Court normally does not interfere in High Court decisions, and that too on a question of evidence where evidence was not available in the first place. So you have a classic case where the Supreme Court can simply say, no, I refuse to interfere. And that the consequence of that is that the person who is in detention continually stays in detention, and there were no mechanisms to get them out. There have the realization that this kind of indefinite detention cannot go on was what then prompted the Supreme Court to come out with this halfway house sort of order, where people who were detained for nearly two years or 3 years were let out on their own recognizance. Their status is unclear, and because they were declared foreigners, then the people who claim descent through them, or people who are related to them, their brothers, their sisters, all those citizenship status also comes under a cloud. Now, in this context came the Supreme Court order of revising the NRC, which was conducted in 1941. You will remember how me telling you about what happened in 1947-48 with partition and with people going back and forth. At that point of time, there was a non-public exercise taken administratively, where the local administration created lists of citizens whom they were thought undoubtedly were qualified for citizenship of the new country. This was a process which happened in Assam alone. This process, however, was not comprehensive. It was not comprehensive and in various districts incomplete. Nevertheless, the Supreme Court ordered the authorities to update the list by allowing people to produce evidence that they were indeed related to somebody who was there on the 1951 list. So in a sense, it was like Schindler's List being updated to include all the descendants. The Supreme Court never really spelled out what would be the utility of the list, or what would happen to those who failed to prove their descent from people who were there in 1951. It also failed to see the problem as a whole and say that even those who could not prove ancestry through this process would have other ways to prove citizenship. So you effectively today have an updated list which has not satisfied anyone, which has not come anywhere near the numbers that were alleged to be illegal infiltrators within the state of Assam. And that people who are left out of that list do not really have a path of citizenship of either India or Bangladesh, and they are likely to be in a state of statelessness. And what happens to those who derive to their descendants is another question for a future date. The role of the Supreme Court throughout this entire process has been one of failing to grasp the larger picture. It has acted upon the basis, upon an inarticulate premise that nativism and ethnicity is the only basis for citizenship. Before I finish, I'll give you a case of two people called Ashraf and Kismat, who were caught in this process, who finally got out with the combined help of me and the next speaker, Aman Wadud. Now, Ashraf and Kismat had their ancestry in UP and Bihar. Their ancestors had migrated to Assam after 1951. So obviously, they could not have been in the 1951 list. They were declared to be foreigners ex parte, taken into custody, and then some of their relatives who were working with somebody in Pune finally got in touch with me through social media. Then when we filed the case in the Supreme Court with documents which proved the ancestry from UP and Bihar, the Supreme Court did not accept it at first blush. It asked for the CBI to go in, probe, and come back with a report. The CBI came in with a report and confirmed it, and the Supreme Court did not automatically accept that. It then remanded the matter back to the Foreigners Tribunal, and the Foreigners Tribunal finally, with Aman's help, held both of them to be citizens and then freed them. So there's a little picture of, I think it was Ashraf with his daughter, which still remains as the screensaver of one of my colleagues who worked on the matter. We still remember matters like those as our little contribution to this fight against statelessness. For us, at the end of this process, are real human beings in real trouble. We do our little bit, but it is a mere drop in the ocean. The answers are systemic. These kind of declarations of non-citizenship and declarations of statelessness ought not to be done in this massive manner in a routine fashion without thinking through the consequences. It remains a blot on India's proud record of having been built as a civilization by waves and waves of people who have come and who have made this their home, flourished, contributed, and then having had no other identity than as proud Indians. It can't be that poor Indians get the rough end of the stick. Thank you for a patient listening.
Thank you, Sanjay, for that very extensive and in-depth telling us about the whole range of issues, starting from Assam's history and how this is a systemic problem, and whatever people are doing in terms of legally supporting those who are charged as foreigners is just a drop in the ocean. And the whole NRC process, how it was done by the Supreme Court without thinking through what will this list do, what will happen with this list. There was absolutely no thinking on that. And so some of the and that also that the Supreme Court did not grasp the larger picture. Some of these things, and your own case, the Ashraf case that you represented in Supreme Court. Thank you for sharing all these, and the whole issue of the Foreigners Act versus the Illegal Migrants Determination Tribunal Act, and which was, I mean, we have a problem where the resident population is being charged as citizens, and as you said during the British India, Foreigners Act was meant for those who are recognizable foreigners, not for resident population. So all these contradictions obviously are there. Thank you for sharing all of these. I think we'll take just to remind all the attendees that you can put in your uh, questions and comments and observations, whatever clarifications you want to in the Q&A section. At the end of the presentations, we will have all the panelists will answer the questions. Thank you. Then I will ask Anshuman to make his presentation. Along with that, when he wants, he can tell us when to release the report, and he will also share his views and data on the report we have come out with on COVID exclusions in Assam. Over to you, Anshuman.
Thanks, Ravi. Thank you so much. Before I begin my remarks, I must say I must really thank Mr. Sanjay Hegre for his very incisive and on-point interventions from various aspects. And I would also like to thank Anjuman for that very moving and I would rather say disturbing presentation and candidly disturbing presentation, because that is what Assam citizenship crisis is all about at the moment. So thank you for bringing out those stories. I think in the broader national context of India, statelessness prevention is all about creating a norm where there is none, literally. In fact, to the point that the entire term statelessness is largely missing from the legislative or policy and to some extent the legal vocabulary. There are various documents that India has signed or ratified, international documents. For instance, the most obvious one being the Universal Declaration of Human Rights, which has the right to nationality embedded within it. But given the non-legally binding nature of those documents, I don't think our policy framework ever bothered to, develop safeguards to prevent statelessness. And the ramifications of those we are seeing today. And over time, I think the Indian nationality framework has become narrower, even instead of expanding. Citizenship rules that have been devised have become rife with gaps and loopholes through which people fall and become stateless. And now that we have policy regimes like the National Register of Citizens and the Citizenship Amendment Act, these things only compound these gaps. These things only exploit and compound these gaps. And this narrowing of the Indian citizenship framework, in fact, goes much before the current government came in. It started from, we could say, the late 70s and 80s and kept becoming narrower and narrower. And all successive governments are responsible for it in many ways. And as I said, the idea of statelessness is scarcely reflected in the policy language or the legal language, and to the point where state ministers get in public, they talk about statelessness in a very very casual, almost humorous way, as if it's something desirable. And this is something. This is a specific example that I'm giving you. So I think it's a gigantic task for civil society to build the norm of statelessness prevention in a context like India, which is so complex and also at the same time, has a very complicated history of regional migration in and out, right? So I think from this, what I want to talk about, which is already been talked about, is quote unquote, if I may call it this, the Assam model. Now, I've written about this in the past, and why do I call it a model? Because I really think this is a prototype. This is a prototype which can be emulated in other contexts. For example, if the NRC goes national, of course, it won't be emulated in the exact same format or with the exact same rules, but in many ways, this is a living prototype of how statelessness can affect lives, can split families down the middle, and cause structural exclusions. And I think the Assam model truly reflects the entire idea that the right to nationality is a gateway to all other rights. It actually results in multi-structural and multi-layered marginalization. And I think why the Assam model is important is because it's very complex and elaborate. And I think that has two specific implications, which is one, it makes it difficult for a person to defend themselves in front of such a complex structure, right? And second, it makes it difficult for civil society to also make effective interventions, because the layers are so much, the levels of marginalization and state-sponsored disenfranchisement are so elaborate that that interventions have to be made on various levels, and that becomes an arduous task. Which of course doesn't mean that civil society should not intervene. I think they should take small steps towards that. But this complexity and this intricacy of this whole structure, this citizenship determination regime in Assam, I think is makes the situation even more compounded. And the Assam crisis, citizenship crisis, is actually about many crises stacked on top of each other. If I might call it that, statelessness, floods, forced displacement in the form of evictions, let's say, and finally COVID-19 that we are seeing today. Now, I think this brings me to our report, our first report, based on ground surveys of at-risk people in Assam. And I'm very happy, in fact, today to be releasing this report during this webinar. And if you might allow me, I'll just share my screen. Yes, thank you, Mr. Sanjay, for doing that. And I also, Ravi was kind enough to send me a copy, hard copy, but I'll just be sharing. Just a moment. Don't know why it's not happening now. I'm sorry, just give me a moment. It's not visible, is it yet?
We can't see. Yes,
I think you can see now.
yes, we can see that you have started sharing, screen sharing. Yeah. All right.
Right. Give me a moment. Right. So you can see the first the cover page, right?
Yeah.
I just want to make sure I'm sharing the right screen. And now you can see the second page.
No, not yet. Still the cover page.
We can see the list of the pages, but not a particular page. So you'll have to, I think you
Okay.
will have to click the page
Just give me a moment.
to display.
Okay, this is causing a fair bit of trouble. Okay, you should be able to see now. So this is the report that we have produced, and I'm very happy to be releasing it right now. It's called "Marginalized and Impoverished in Assam." It's essentially a study into the exclusion of those at risk of statelessness in COVID-19 responses and social security provision. So essentially, what the report surveys is the intersection of two crises, which is the statelessness crisis and the COVID-19 crisis, right? And what I would like to do today is share some highlights or key findings from the report that are indicative of the larger structural exclusion that this entire citizenship crisis and the COVID-19 pandemic together have caused, right? And before that, quickly, I would like to mention here that the lead researcher of this report is Padmini Barua. We would really like to thank her. I would like to take this opportunity to thank her to do this for doing this fantastic job in collecting data from the ground despite the threat of pandemic and despite the threat of infections. Along with us, 7 other data collectors have done the data collection, and mostly we have relied on qualitative interviews and also some bit of quantitative data sets that we have produced from those interviews. In total, we chose around 67 respondents from 8 different districts to highlight, sort of, to capture the entire geographical spectrum of exclusion in many ways, and also the social spectrum. 4 sets of people were essentially interviewed. Number one, FT process initiated. Essentially, those were under trial at the foreigners tribunals. Number two, Number two, declared foreigners who have not yet been sent to detention centers but are declared foreigners or DFs. Released detainees who have been released from the detention centers. And number four, NRC excluded, whose names have not featured in the final draft of the National Register of Citizens. And we essentially probed the entire data survey happened across three key questions, which is the respondents' experiences with the legal system, the socio-economic challenges that they were undergoing due to the lockdown, and their lived reality in terms of accessing relief from state and non-state actors during the COVID-19 lockdown, right? Now, there are a bunch of findings, but I'll just highlight some key findings that are indicative of broader patterns. One of the key findings that the report concludes or has is that the respondents indicated challenges in being able to procure essential goods and services during the lockdown period. They encountered significant financial and information challenges while navigating the legal journey of citizenship verification, lack of information about legal procedure, difficulties in procuring payments for lawyers, and lack of proper documentations of other things, right? And now this takes me back to my earlier point that, there is the complexity of the system is such that ordinary people or common people are not able to grasp the legalities, the finer legalities or the complexities of the whole system. And this is where, awareness campaigns about legal awareness campaigns about the various laws and how to challenge, how to defend an individual from these laws comes in. And this is also where people like Aman Wadud are making very critical interventions through their constitutional workshops such as Samvidan, right? And taking it really to the hinterlands, to the rural areas where most of the disenfranchised crowds, disenfranchised people live, right? Now, in terms of specific findings, let me quickly come to the findings bit. Right. So these were the 8 districts that were surveyed as part of this report, and you can see the divisions of the respondents by gender, by sources of income, and categories of respondents in terms of what I just explained. Now, if you see this in terms of the impact of COVID-19 of the lockdown on at-risk people, as I said, one of the things that the report surveys is the socio-economic challenges that the respondents faced during the lockdown, right? And almost 91% of the respondents reported not being able to find any work during the lockdown, as you can see from this graphic. Now, 88% of the respondents, and 91% of course is a huge number, it's a massive number, and 88% of the respondents stated that they did not have any access to health services during the lockdown, right? 78% of the respondents claimed to be unaware of various government schemes that had been instituted for relief. So you see how citizenship disenfranchisement has also sort of physically cut off at-risk people from state welfare, right? And they're not even aware that there are certain welfare schemes by the government, right? As you see, this is the health survey data that we have, access to health services. Now, if you see this, respondents who did not receive ration or state ration or through the public distribution system, you see 39, the majority of the share is held by the released detainees who have been released from detention centers but are not able to now procure state subsidies or subsidized ration, right? Now this is around 30% of the respondents interviewed did not have a ration card at all, right? And of this, the vast majority comprised of released detainees, which is 33%, right? Because these detainees came out of detention centers and while applying for papers or while applying for a ration card, they faced immense hardships simply because they were ex-detainees, right? And the strictly imposed lockdown, I think, challenges as they had to make the journey. Because of the lockdown, they could not actually make the physical journey to the public distribution system points, right, from where you procure the rations. So there is a physical barrier also due to the lockdown which affected the respondents. Now, 2/3 of the respondents reported not having any form of assistance. Now, two-thirds in this case would mean around 74%, right? Of these, most of the persons were those who had been declared foreigners or were released detainees, and an overwhelming majority of the respondents who did receive actually cash transfers were women, right? So let me just show you this graphic, right? As you can see, 74% did not receive any cash transfer from the government, which the government had promised, right? And most of them are released detainees, followed by foreigner tribunal under trials, right? And I think beyond this data, like the data itself is, I would say, self-explanatory in many ways. You can see the massive number of people who have been cut off from state services because of because of the liminal citizenship status, right? So you see, it's a double whammy for a particular set of people. We know the COVID-19 lockdown, the very strict lockdown in India affected a large set of people across the country, mostly the economically and socially vulnerable people. But within Assam, this particular for this particular set of people, it was a double hammy. It was a pincer attack from both sides because of their sort of vulnerable citizenship status, right? And I think I would like to focus on one or two particular case studies that we have brought out. If you see this case study, without being named, the person being named, most of the names in the report have been changed for security and of the particular respondents. This particular respondent says, one evening as I was returning from the market, I was accosted by the border police. They produced a list and asked me if I knew anyone on it. On scanning the list, I found my own name there. I was terrified and told them that I did not recognize any of the names. I returned home immediately. The border police eventually found out my address and left a notice there calling for me to be present to present documents and evidence. So you see, it's almost like a case of you wake up one fine morning and there's a notice on your doorstep saying either you have been declared a foreigner through an ex parte judgment in the foreign tribunal, or you have been summoned, or you are a suspected illegal immigrant and have been summoned to a foreigner tribunal. So this is the kind of sort of vulnerability that millions in Assam are living in right now. And even if they produce the right papers, the core of this entire matter is that even if they produce the right papers, there is never a surety of inclusion. It always hangs on a thread. There is just a chance or possibility of inclusion. So you see, even ticking the boxes that the state have laid out for you isn't enough in many ways. The other case study that I would like to read out, this is the last case study I'm reading out, is of Jubeda Begum. Obviously, names have been changed here again. I think this case study aptly captures the intersection of two crises, which is COVID-19 and statelessness. So, Juveda's husband was unable to find work both due to the lockdown as well as health concerns. She did not have a ration card herself. She's not a Jan Dhan account holder. Jan Dhan account is a government scheme where cash direct benefit DBTs or direct benefit transfers happen to the account holders. So she was not a Jan Dhan account holder and so did not receive the sum of money promised. Now, given her status as a released detainee, she was in a detention center earlier, and she has been released later. Given a status of a released detainee, she is required to travel to the police station once every week. A journey of 26 kilometers that she undertakes on foot. Now just imagine the ordeal of this particular person, right? That person has to report to a police station every week and undertake a journey of 26 kilometers. It's almost nearly unthinkable for us, right? Many of us. This takes around 5 hours every day. Look at the opportunity costs. Look at the high, the degree of time per day that she's losing out, which she could have expended in other things that could have perhaps given her some financial benefit. This takes around 5 hours every single time. Her health conditions make this exceedingly challenging. Further, the floods have displaced her from her home. Her husband is also a D voter, a doubtful voter, which is a very specific electoral category for Assam, where certain suspected, quote unquote, suspected illegal immigrants are struck off from the voters list and are labeled as D voter. Her husband is also a D voter and her entire family has been excluded from the NRC. She says, Amar Porial tok Nagorikottor Kola Meghe Dhaki Dhorise in Assamese. This means citizenship has become a dark cloud over our family. I think this very poignantly and painfully captures, the endless misery and the circular miseries of people in Assam because of the citizenship, crisis. I think we'll be sending an exclusive link to this report. This report hasn't been uploaded on our website yet. It will be done in the next few days after a few more rounds of review. But there is this particular exclusive copy that we have. I think someone can share this. Perhaps Alina can share this with all our attendees. So you can go and check out this report, download this report, and read it and share it. And once it's uploaded on our website, we'll be sharing it even more extensively. I just briefly captured some glimpses from this report. I urge you to go through the entire report. I urge you to study the context. There are various annexures which explain the foreigner tribunal process, which Mr. Sanjay Agre right now very lucidly also did. The entire history of immigration, and then the history of the citizenship crisis. So I think we will be doing more such studies in the future and more such ground surveys from the future. And finally, I just want to again reiterate my point that interventions, civil society interventions in this case, have to be multi-pronged. They have to be legal, they have to be a sort of documentary, academic, and also at some level media or public relations interventions. Because we are essentially, what we are doing here is building a norm that statelessness is not acceptable, cannot be acceptable under any circumstance. And the moment an individual becomes stateless for whatever reasons, perhaps because of the state's own doing, that needs to be prevented right at that juncture, right? So I think that is all that I wanted to say for now. And if there are any questions, I would be happy to address them.
Thank you, Anshuman. I think you have shared the report and the findings and other issues in detail. So I will not go. For the attendees, it's already there. The link to the report that Anshuman mentioned about, it is there in the chat box, so you can access that report easily through the link. Now I straight away ask Aman Vadud, the advocate, is here. So I'll straight away ask him to share his experiences and his understanding of the foreigners issue and how the tribunals function and the High Court and other legal issues. So Aman, over to you. And please share your screen as well.
Oh, can you hear me now? Sorry.
I can hear, yes. Yes, we can hear you and you can see you.
Okay. My sincere apologies for joining late. Actually, I'm in Jorhat. I came to argue a case of a person who came here in 10, 12 years back. He was a daily wage laborer, and he was accused of being an illegal migrant. And subsequently, he was declared a foreigner by ex parte order. I fought the case in the High Court. We remanded it to the tribunal here, and he was detained once because his lawyer did not appear. He was late actually. He was detained, and then he was released again. And then now, last few hearings, I am appearing for him. I argued the matter today. Hopefully, we will save him from detention. I hope. So thank you so much for inviting me. It's a great privilege to be here, particularly sharing screen with my mentor, Mr. Sanjay Hegde sir. I missed his lecture. I hope it's on YouTube. I will go through it, and it's always a pleasure and a learning experience to listen to Mr. Sanjay Hegde, for whom I have the greatest respect. Firstly, we are talking about statelessness here. The state do not acknowledge statelessness. For them, these are not stateless people. For the state, for the authorities, these are quote unquote Bangladeshis and not stateless people. Of course, India is not a contracting party to the two statelessness convention. And that apart, these peoples are not regarded as stateless. So for them, they are Bangladeshis. They illegally migrated from Bangladesh, the people who are caught in this entire citizenship angle. I remember, because Sanjay sir is here, let me also mention about due process. That we are the only country maybe where we are manufacturing stateless people by pretending that we are following due process. Due process is not followed. what is due process? It's legal proceeding which works according to the established principle of law, which do not violate natural justice, which follows the basic jurisprudence. What is happening here is far, far away from what due process is. This is definitely not due process. Example, the most glaring example is there are millions of every case is an example, but let me mention about Mr. Sanaullah, who was an Indian Army officer, whose case we are fighting before the Guwahati High Court. He was detained. We got his release after 10 days of detention. Miss Indra Jaising argued the case, and this is a rare case where a person detained in detention center have been released just within 10 days. When his so-called confession statement was forged, his thumb impression was put on the day when he was working for the Indian Army in Manipur for a counter-insurgency program called Hifazat, which means security. So when he was securing India in Manipur, the Assam border police was accusing him of being an illegal migrant. This is not due process. He appeared before the tribunal. He submitted 26 documents. One of the document was a certificate issued by the Honorable President of India, where he was appointed as JCO, which is Junior Commissioned Officer. This document was rejected. The reason given was it is not proved as per evidence law. Basically, she was expecting that the person who issued the document appear before the tribunal and say that I have issued the document. Let me put it in simple words. The foreigners tribunal member expect that the President of India comes before the tribunal and say that I have issued the document. I don't know whether to laugh or to cry, but this is ridiculous is a kind word. This is the document that the tribunal or any judicial forum should have admitted. They should have taken judicial cognizance of the document and right away admitted the document. Prima facie, you can come to a conclusion that a person who was in the Indian Army, who served the Indian Army for 30 long years, can't be a foreigner. There are back-end checks. A person who has served so much for this nation can't be a foreigner. And then he submitted on 26 documents. 4 or 5 witnesses came and deposed before him. How can he be a foreigner? But despite that, he was declared a foreigner and detained in detention center. Not due process. So what is happening is a complete breakdown, complete violation of the due process, which every citizen of this country or non-citizen is guaranteed actually. And that is how the Foreigners Tribunal is declaring Indian citizens as foreigner. So because we are talking about the COVID response, let me briefly explain that the Honorable Supreme Court, the bench led by the Honorable Chief Justice of India, took a suo motu petition saying that to decongest the prisons across India, across the country in the wake of the COVID-19. We thought we have an organization called Justice and Liberty Initiative. We thought this is a good time to go to the Honorable Supreme Court and ask to release detainees also, because if people with who have been convicted of petty crimes can be released, why not these so-called declared foreigners? Because they have not done any crime. Being declared as a foreigner is not something which has penal consequence. Take out the Assam, the foreigners report, the white paper on foreigners issue the government of Assam has published. It says on record that detention is with the sole intent to deport these detainees to the country of origin. In the last 7 years, since 13/3 to 2013, since when the formal process of deportation started, the government of Assam on record in affidavit said that they have declared only 4 people. So the bottom line is that detention, forget about the due process for a while, the foreigners tribunal for a while. Even then, the people who are declared as foreigner in a very arbitrary manner, their detention is not serving any purpose, going by the sole intent to detain these people. Uh, so we went to the Honorable Supreme Court. We said that the 3 years of mandatory detention, which a cap was put to indefinite detention when Mr. Harsh Mandar went to the Supreme Court. He was removed as the petitioner, but the Honorable Supreme Court said that you can't, a person who is detained for more than 3 years should be released with the condition that he should furnish 2 sureties of 1 lakh each and should appear before the police station every week. Uh, I would say very unreasonable conditions. So we say that dispense with these conditions, dispense with the with the appearance every week, and we were praying this during the COVID. We prayed that dispense with the 1 lakh surety to Indian citizen, dispense with it. We prayed that dispense with the entire detention period. The Honorable Supreme Court, by its order dated 13/4/2020, was pleased to come order that reduce the detention from 3 to 2 years and reduce the surety bond from 1 lakh to 5,000. And but it did not do anything with the appearance, the periodic appearance that the detainee should make to the local police station every week. So after our order, more than 350 detainees have been released, one of them being Minara Begum. Minara Begum was detained in 2010 when her daughter was only 15 days old. Uh, she went to the detention center along with her daughter. Her daughter grew up in detention center. Despite Hashmander's case, that order, which put a outer limitation of 3 years, she was not released because there was no one who could furnish the 1 lakh surety bond. When it was reduced to 5,000, although it's not a cash, but you need property which is above 1 lakh. So when it was reduced to 5,000, she was released after 10 years in detention. And like Anshuman read, in the report, that is a very beautiful report that you all have come up with. She was suffering. She was suffering financially, and because she was out of detention after 10 years. So a small help was rendered to her, which is definitely not enough. But I have seen firsthand how people, even released out of from detention, was suffering, apart from these people who were not detained. So first thing, it was very difficult to appear before the police station every week. Another detainee, Momiron Nessa, she was there for 9 years. She was released after the Harsh Mandar petition, and she have to appear before the police station like every which is around 12 kilometer, and she had to appear um, to follow the condition. Otherwise, she would have been detained again, because that is the condition on which she was released. So traveling 12 plus 12 kilometer, for a woman, a frail woman who was in detention center for 9 years, is definitely not easy. I think only one time she was asked not to appear was when the entire police station got COVID-19. So I think for a month or so um, she was allowed not to appear. So these are the conditions under which even people who were released uh, had to undergo. Apart from that, uh, when a person is released from detention centers after 3, 4, 5, 6, 10 years, they face a lot of economic um problem, for the very reason that there was lockdown. They were out and they had no resources to sustain. Another thing, COVID or not COVID, when you put such harsh condition of appearing before the police station every week, when you go to work, most of these peoples are from rural areas. How do you go away from your home to urban areas to work? So I very sincerely think that the conditions to appear before the police station every week is unreasonable. Another specific case of Asghar Ali. He's from Calcutta. After our order, he was also released. His father was suffering from throat cancer. He was not allowed to go. He couldn't go because there was no flight, nothing, no communication. So although his father heard, his only dream was to see his son free. His father was in Calcutta. He died as girl. He couldn't see his father. Here, I would say that the police did help him. I mean, because this was the peak of lockdown in Assam. Even apart from ambulance, there were no vehicle that was allowed to fly. But in the Asghar Ali case, the border police in Guwahati actually made arrangement for the sureties, two Indian citizens who came from Nalbari district, which is like 70 kilometers away. So they only arranged the vehicle to bring them from Nalbari, which I appreciate. I mean, without that help, police help, it would not have been possible to ensure his release. Subsequently, of course, with police van, he was brought from Gwalpara to Guwahati. So in lockdown, basically everyone suffered, but the kind of suffering the people who have been declared as foreigner and now have been rendered stateless underwent is unimaginable. Those who were released after our order, 350 odd people, I just can't imagine. I mean, what they went through, uh, the financial strain that they faced is unimaginable. There are people who came out of detention after 10 years, and there were hardly any helping hand to help them. God only knows how they sustain all this while. So briefly, the bottom line is that all these people who were released, 350 people, more than 350 people now, and around 300 people after the Harsh Mandar petition, 650 people were released in the last 2 years. Where did they go? They are here in India. They are here at their home with their family member. Why were they detained then? If the sole intent to detain them is that they can be traced during the time of deportation, then there is no meaning of detention. Of course, another thing is that if they are here, resident of this country, citizen of this country, actually, their entire family members are citizen, why were they declared as foreigner, right? Statelessness is, of course, is increasing everywhere, but I don't think there is any country in the world which is rendering its own citizen as stateless. Uh, After the 1982 legislation that Myanmar brought, the Rohingyas were rendered stateless, but that was like en masse. They were done en masse, and they didn't pretend that we are following any due process, right? We are pretending that we are following due process. Which country? India, which is governed by the Indian Constitution. And I very sincerely believe that this is a great document, an unparalleled document in the history of modern nation. The preamble that we have, which calls for social justice, liberty, dignity of individual, all these noble words, noble ideas. Um, if you read FT Foreigners Tribunal judgment, if you see the procedure before them, if you see how people suffer, uh, you know, our founding fathers would be turning in their grave. This is not the country that they envisaged, that they dreamed for. This is not India of Gandhi's dream, India of Ambedkar dream, India of Nehru, Maulana Azad's dream. Uh, so what is happening today is slaughter of the values enshrined in the Indian Constitution, and that's how Indian citizens are rendered stateless. Thank you so much.
Thank you, Aman, for that wonderful sharing from your experiences in Assam, and I mean all kinds of detention issues and how people are being made stateless, and the manufacturing of statelessness, as you have termed it. These are very important issues. Now I'll straight away ask Amal to come on, and we have all of us speakers here have shared so much about what's happening in Assam and India. I think it will be good to listen to Amal, who will bring in the international global statelessness situations experience. And how do we, Sanjay also mentioned that this is a systematic issue. How do we engage with this issue and problem is what something we can hope Amal will talk about. So Amal, over to you.
Thank you very much, Ravi, and thank you to all the speakers who came before me. It's always an education for me to learn from colleagues such as you, speaking about the situation in Assam. And today, I just learned so much. My massive congratulations to the Nationality and Citizenship Rights Network as well for this report, which I think is a fantastic resource, and it's the latest in a series of very important contributions that have come out over the past few months on the situation in India, both in terms of the NRC and also the CAA, but also with this report tying that to COVID-19. And I think it just builds this volume of evidence and argument, which is going to make it difficult to ignore. And I hope that resources and tools such as this are used in advocacy efforts as a go ahead to engage government and push for the change that really needs to happen. So as Ravi said, what I'm going to do is I'm going to try and take a step back and reflect a bit on what I've learned from my position at ISI, where we have the privilege of working with partners around the world. And so we have gained a bit of a global view and insights and comparisons from different situations, different histories. Uh, and what is striking is that actually there are a number of similar themes and commonalities which come out when you are able to look at issues in a comparative way. And what this shows is that actually there is a playbook which we're definitely being seen, as Anshuman you mentioned, through the NRC, which can potentially be replicated in other parts of India as well. But this is also a playbook which, in different guises, has been used by different states in different contexts around the world and will continue to be used. And so I think it's important that we are able to learn from each other and to draw from each other's experiences and contexts, because with that knowledge and comparative insight, I think we will all be better equipped to fight the undemocratic and the anti-human rights projects, which are often at the base of nationality deprivation, citizenship stripping, and the denial and deprivation of rights of stateless people. So what I've been increasingly kind of reflecting on over the last year in particular, with COVID-19 as well, is the way nationality, the notion of nationality, the way it interrelates to, and the way it is shaped by other large, significant social challenges and phenomena that we see in the world. So whether it is the rise of populism and authoritarianism, or whether it is the targeting of minorities, or the preservation and protection of democracy and the rule of law, the way nationality has emerged over the last few years in particular as something which is central to this deeper story around how our countries shape themselves, how they shape their polities, and how this in turn kind of has a deep impact on the rights of people and citizens, or non-citizens as they may become, is something which I think really deserves further study and insight. And what I've also realized, particularly in the context of COVID, is that it's important to look at this both as an issue which has a deep impact on individuals and families and communities in normal times, uh, and these impacts are further exacerbated and further brought out in times of crisis, as the COVID-19 pandemic has shown us. So I'm going to frame my comments around these few ideas and themes of nationality, populism and authoritarianism, democracy and the rule of law, the impact this has on communities, and the exacerbated impact in times of crisis. So let me start with nationality. And I think this is a concept which you would find people approach in different ways based on what their perspective is, based on what their agenda and interest is. So depending on who you speak to, you may find nationality being described and defined as a human right, or as a privilege, or as a matter which is strictly and exclusively uh, related to state sovereignty, and it's up to states to determine who a citizen is or is not, or is a matter which is framed by international law and standards, and which in some ways limit the expression and of state sovereignty in this regard. And I'm going to come back to what I perceive, and certainly what the Institute perceives to be the position with regard to nationality from an international law perspective. But I just want you to hold on to that thought as I go through the rest of my presentation here, that there are different viewpoints and perspectives as to what nationality is and where the right to shape nationality derives from. Is it does it lie with the individual? Is it an individual right? Or is it something which is completely at the discretion of the state? Or is it something which lies somewhere in between, where there are various standards and principles which shape the way this is experienced by both the individual and the state? So let's come back to that at the very end, but just bear that in mind as we go along. Now, whatever your perspective is, what has become clear, whether you look at the Rohingya crisis, as Aman spoke about, or other situations around the world, or indeed what's happening in India right now, is that nationality is a very powerful concept, and states know the power of utilizing nationality as a weapon to exclude. So through the power of nationality and the ability of the state to determine who is and is not a citizen, or what makes a citizen become a non-citizen at some point, through this life-changing power, states have, over the period of history, and we can go back to pre-World War II and the treatment of the Jews by Nazi Germany. We can go back even before World War II. You find that states have this incredibly powerful weapon, which they utilize against minorities, but also against political dissidents and human rights defenders, and as we've seen increasingly post 9/11, against terrorists and suspect terrorists. And so you have a tool which perhaps we as citizens of the world have underestimated in terms of the significance and power of this tool that states tend to use to their advantage, and often in a way which undermines the rights of citizens. And what we've seen is, if you look at what's happened in the world over the last few years in particular, with this rising wave of populism that we've seen in many countries globally, that this has become a tool that has been increasingly used by populist governments and by authoritarian governments alike. And there's, of course, a spectrum which moves you from populism potentially into the territory of authoritarianism. And this is a very powerful tool because it's the oldest trick in the book of you pick out a minority who stands out for some reason or another, their history of migration, their race, their religion, their language, whatever it may be, and you start blaming your failings and the problems that you are responsible to address on that minority. And then that becomes a way both of absolving yourself but creating a bigger enemy to kind of focus the attention of the majority on. And the real power of this tool, I believe, is not just the short-term power of being able to do this and create an other, but it is to use that other to justify the erosion of democratic institutions and principles and values. So you will justify the poor implementation of the rule of law or of due process, because who is being targeted through this is unpopular. It's the Rohingya of Myanmar, or it is suspect illegal immigrants from Bangladesh in India, or it is the Kuwaiti Bidun, or it is Dominicans of Haitian origin in the Dominican Republic. And so you build a public consensus which allows the executive of the state to concentrate more power and to act with greater impunity. And this power, once grabbed, can then be used in other situations and in other contexts. In India, what's happening right now with the farmers' protests is a perfect example of a state which has grabbed more power and justified the use of power through targeting minorities in different contexts, and now is exerting that power in a situation which it probably wouldn't have been able to do so a number of years ago if it hadn't laid the foundation to do it. And so I think this is why we need to be very careful and very mindful of the way minorities are treated and excluded and the way nationality is used as a weapon and the impact this has on due process and other basic democratic norms, because this is often the beginning of the worst that's yet to come. If you want to gauge the health of a democracy, ask the minority, ask the community whose citizenship is under question, ask the excluded. And you will see that notions of bureaucratic violence or direct violence often play a role in paving the way for democracy to be taken, shaped in a way where it's no longer democratic, it's only democracy in name. I mean, you look at the experience of the Rohingya community in Myanmar, the genocide that they faced in 2017, at a time when the international community was celebrating a so-called move towards democratization within Myanmar. And we have the coup that happened very recently, which exposed the fallacy of this idea that Myanmar was moving towards democratization. But if you ask the Rohingya or other minorities in Myanmar whether the country was moving towards democracy, they would have said no. In the Dominican Republic, the idea that an entire ethnic community, the Dominicans of Haitian origin, could be stripped of their citizenship has been described by that community as an act of civil genocide. And again, I see similarities with what Aman was describing in India as well, where again it was the power of bureaucracy, the power of due process, which was used in the Dominican Republic to justify erosion of rights and to justify the manner in which an entire community can be excluded. So this is why I think this issue is important, not only as an individual rights issue, but also as a deeper issue of democracy and the rule of law. And this is why it's an issue which is important for each and every one of us, not only those of us who belong to minority communities or have a particular interest in minority rights. And then we get to the question of what are the impacts and consequences of this. Now, the reason citizenship deprivation is such a powerful tool is because the consequences of citizenship deprivation are huge and they can be very significant. In other words, states do this because it works. And if you look at any large scale situation of statelessness in the world today, you will often be able to put your finger on a historical point which marked the beginning of the end, whether it was the introduction of a law or a census or some kind of policy approach or reform or a Supreme Court judgment, a moment in history which made it possible for a minority which was most likely enduring discrimination in a structural way before that to suddenly be treated as not being citizens and being stateless, which then becomes a narrative which reinforces why they're treated that way. So it's a self-fulfilling kind of circle. So if you look at the Kuwaiti Bidun or the Syrian Kurds, the Rohingya, the hill tribes of Thailand, whichever stateless community you look at, you will be able to go back to a particular point of history and say, this is where the discrimination that a community endured went a step up and was ratcheted up and became actually the deprivation of their citizenship, which was then used to reinforce further discrimination and further structural discrimination. And India is in this moment now. It has been in this moment for the last few years with the NRC process. And the lessons that we can learn from other parts of the world is that if it's not nipped in the bud, it's going to get worse. And the worst it can get is what has happened to the Rohingya with an actual genocide. But even if it doesn't end up there, you will still end up with a situation of a community that over generations, in an intergenerational manner, has been structurally excluded from the right to access healthcare, the right to education, the right to work. They've been more liable to be picked up and detained, etc. And this means that as we see in our experience a general trajectory of development over generations, you find with these large stateless communities actually the opposite, where the children and the grandchildren are worse off than their parents and their grandparents, which is not the general trajectory of the world. And so you see a huge widening of the gap over many generations, which is what can potentially happen in Assam as well. And my final point in terms of where this leads us and my reflections on COVID-19 is that we see these structural discriminations and exclusions and marginalizations and the impact these have on individuals really come out and heightened in a time of crisis. So my organization, we were quick to understand that COVID-19 was having a very particular impact on stateless communities around the world. And so we worked with partners, including Daji, Ravi's organization, and others around the world to respond to this. We analyzed the COVID-19 impact on certain communities, and we were able to raise funds to work with partners to actually try and address the situation in different countries around the world. And what we've seen through COVID-19 and what comes out so clearly in the context of the report that has been launched today is that COVID-19 makes an already unbearable situation even worse. And it means that a community in that situation has even less access to whatever public relief a government may make available to its citizens. And so it's up to us to identify that these are deep structural inequalities which need to be addressed at their root in order to be able to actually do so in a sustainable way. So let me end then by going back to the question that I started with, which is this concept of nationality and how nationality should be viewed. Is it a right? Is it a matter purely of state sovereignty? Is it a privilege? Is it shaped by international law? And I mean, if you approach this from an international law perspective, as I do, then what is clear is that yes, it is absolutely a right, but also it is an area in which states do have the sovereignty to determine how their nationality will be shaped and who is considered a citizen and who is not. And the role that international law plays is a balancing of the individual's right to nationality and the state's sovereignty to determine who its citizens are. And so what we find is a set of international principles which shape and limit state sovereignty, but do not dictate terms in a blanket way as to how nationality should be uh, uh, kind of addressed by states. So states still are very much within their discretion to decide on what basis nationality is granted. Is it by birth on the territory, for example, or is it by descent? What rules apply in the context of naturalization, etc. But in doing so, states must ensure that certain basic principles and norms are respected and not contravened. And these relate to the very basic norm of the prohibition of arbitrary deprivation of nationality, which you will find in the Universal Declaration of Human Rights. But it also relates to norms of non-discrimination, and particularly non-discrimination on the basis of race. It relates to norms of the avoidance of statelessness, of due process, which again has come out so strongly in the presentations of the other speakers. And also it relates to the question of proportionality, and which brings into the frame the impact of on the individual as well as on society of deprivation of nationality. So if you are deprived of your nationality, does that mean that you're likely to be detained, thereby undermining your liberty and security as a person? Does it mean you're likely to be deported to a situation which is dangerous to you, undermining a right to life? Does it mean that you're going to be separated from your family, undermining a right to private and family life? Does it mean you're going to be exposed to cruel, inhuman, and degrading treatment? So all of these other human rights, which in many ways are more established, we have a strong understanding uh, and stronger protections domestically. They come into play when nationality is deprived. And that is why nationality needs to be protected and preserved, because it's not just about preserving the link of the individual to the state, but it's also a pivotal right to preserving the person's ability to enjoy their other human rights. Now, we have studied this issue quite extensively. And last year, we published a set of principles on the deprivation of nationality, which you will be able to find on ISI's website, and which goes into detail in terms of what international law allows and does not allow in relation to citizenship stripping. We are also in the midst of now a year of action on this very issue. So a year of action against citizenship stripping. And I would urge you to look at the documents and materials on our site if this is of interest, because what's happening in India is deeply concerning, not only for those of you in India, but also for those of us who are watching from afar. And also the parallels that we can see in terms of the impacts in other countries are something that I think we can collectively learn from. So I urge you to draw from these other experiences and these other histories as you formulate your responses and your strategies to addressing this very real problem in India with very deep human consequences. Let me pause there and hand the floor back to Ravi. Thank you.
Thank you, Amal. You have taken us through the whole issues of statelessness and human rights and principles of arbitrary principles of deprivation of citizenship and avoidance of statelessness and so on. So we have, unless any speaker has any observation or question to make, there are just a couple of questions which are there. We will just, one question is there actually, which I will just reframe the way it has been done. So the question is, how do you, and of course, I mean, in some of the presentations and in Amal's presentation, some of these things have been discussed. The question is, how do you make citizenship see it in the larger human rights violations, and how is it a part of the larger human rights violations? And that the question, and the later on the suggestion is that unless we make that, because at the moment in India, the whole NRC and the deprivation of citizenship is looked at of being of concern to particular communities. So by making it an issue of human rights, it will be possible to um also make it into movement. I mean, that is the thing. So if anyone has something to say on this, these questions are there. But I have something that came up also in other presentations, and also Sanjay Hegde, particularly pointed out about his own experience of representing a case in the Supreme Court. And all of us, Aman Wadud and all of us, some of us here, are supporting people at the local level with legal aid and things like that. I mean, while supporting people through legal aid and legal counsel is important, but as Sanjay said, it's a systemic problem. So how do we deal with that systemic problem? There are huge numbers. I mean, close to 2 million, and now the government is planning to review the list of included people, which basically is that they want to increase the number of excluded. So if there are any ideas on how do we, I mean, if this is a systemic issue, then how do we, what way forward you think? I mean, whether going to the Supreme Court against the whole, because what is happening is that, as Sanjay also pointed out, that people are being alleged to be Bangladeshis without Bangladesh acknowledging them to be their citizens, or any other countries, accepting them as their citizens. So, but the government of India alleges that they are Bangladeshis. So these two questions, if there is any other thought on this, we can have. We can take 5 minutes if there is anything, but. Sanjay, would you like to respond? How do you see when you said systemic problem,
Systemic.
way forward for on this?
I flagged the issue. I would not, if I had solutions, I would have offered it earlier.
Okay.
But see, there is one immediate process, uh, which is to keep people out of detention. Quite
Yeah.
simply that, because once you take that sting away, then people who continue to remain in India, possibly without voting rights or certain other rights, that's a separate fight. The first sting has to be to take away by possibly. I don't see any possibility of legislation. It has to be by judicial intervention. So there are court judgments which say that you cannot unnecessarily arrest people even in criminal cases. Similarly, as Aman said, that there is no point in detention. You may have identified somebody as suspect and subject to deportation. Now you can deport legally only when there is a receiving country. So till the time that there is a receiving country, that they need not be in a detention camp, but be in some way available, is a mechanism that could possibly be worked out through sustained campaigns in the public sphere, added by a court judgment or two. This is one way of it. The second thing has already happened in as much as problems of definition within Assam have cast their shadow on the NRC process countrywide. Now, there has already been, it started as a countrywide discussion. That discussion again has went into cold storage during COVID times, but I believe the discussion will will continue, and that is where we have to decouple ethnicity, nationality from citizenship. There are several nations or ethnicities within India, but an Indian citizen could be from any kind of ethnicity, any kind of language, any kind of culture. That larger message of an overarching Indian citizenship is a campaign which needs great work on. These are two things that come to me top of my mind, and I hope that others have better answers.
No, thank you. I mean, those two are, I mean, yes, I mean, I agree with you that it may not be possible for any other kind of a larger, solution to the larger problem, but detention certainly. And as you rightly said, detention is the main sting, and that is the most, that's the worst the outcome of this whole process. And yes, I think, I mean, that's an important way forward to somehow see that people are not detained. That's I think the way forward. And also the whole, as you have pointed out, there are different communities, ethnicities, and people of different regions, and decouple the whole issue of citizenship and belonging to a community or language, etc. Well taken, Sanjay. Thank you. Any other thing to say before we wrap up?
Ravi, may I just make a quick comment?
Yeah.
I'm just going by the exact question that Tanvi Rastogi has posed in terms of how do you make it, how do you make the demand for citizenship or the issue of citizenship into a people's movement? And I completely agree with Mr. Hegde that judicial interventions in this case sit at the top, right? That's the immediate prerogative for all of us, and for those who are involved in this. But to make it a people's movement, I think in the current context, it's a Herculean task, I would say, because the tragedy, as it might be, that the demand for exclusion or non-citizenship has in fact become a people's movement. The obverse has become a people's movement. In other terms, a populist movement, right? As Amal also rightly pointed out. So there is a majoritarian consensus which is obsessed with words like illegal immigrants, infiltrators, invaders, and these are just the kinder words I'm mentioning, right? So and this has been peddled through various channels, right? And when I say various channels, I also mean court judgments, right? There is a certain document or a report that's published by, let's say, a governor, for instance, the 1997 SK Sinha governor's report about illegal immigration into Assam, which actually projected a lot of misleading figures, right? But that document was quoted in subsequent Supreme Court judgments, including the 2005 judgment. Now, the 2005 judgment was again quoted by in the 2014 NRC judgment. So, you see this in the public, legal, and legislative discourse. This idea of exclusion, this idea of being an illegal, that India's sovereignty being threatened by quote unquote external aggression is what our policy documents use routinely. Has become so entrenched in the public psyche that it's very difficult to reverse that. And this has been going on since the 80s, as I said. Right? The 2003 law, particularly the 2003 law, did a lot of damage in terms of introducing this word illegal immigrants into the lexicon. So I think it's very difficult to make it a people's movement, particularly in context of Assam, where the issue is so emotive that the ethno-majoritarian consensus doesn't even allow a free and unhindered discussion on this to happen. And many of us who work on Assam have personally faced this, the kind of backlash that we see the moment we talk about ethnicity or ethno-majoritarianism and how it's causing exclusions and it's causing miseries to so many people. So I think, the textbook answer is that we do it through public advocacy campaigns, we do it through networks like these, and these are small efforts, but important efforts. But I mean, perhaps it's a bit cynical, but I think this entire idea of taking citizenship into and making it mainstream as a human rights violation, we still have a very, very long way to go in the Indian context. Ravi, are you there?
Yes. So if there are no further comments or observations, and
There
I
is
don't
one
see
question, Ravi.
any more. Hello, you can see me or not?
Yes, I can see you. There is another question by Khush Alam Singh. If you can see the
Yes.
Q&A.
Yes. So would you like to respond to that?
Um, Still to read the question. The short answer to this is yes. The question is, I wanted to gather your thoughts on whether the situation in India is also one of citizenship profiling, where through both legal silence and socio-political narratives, there is a vetting out of a particular version of the citizen, and the excluded or slash precarious minority is thrown the burden of proving that they meet this standard. And the short answer is yes. Even legally, the burden lies on the particular suspect to prove that she or he is a genuine, quote unquote, genuine Indian citizen. And the 2005 the Supreme Court verdict, which struck down the IMDT, actually the IMDT, according to the IMDT, the verdict was the burden was on the state, but by striking it down, going back to the Foreigners Act, I think the burden again falls back to the minority. So yes, there is already a set of precarious minorities, and then there's a double burden on that minority to prove that they are legitimate citizens of this country. And I think this is very interesting because there's a graded level of citizenship that the NRC has produced. And I'm not going into the context, but there is something called the Clause 6 within Section 6A and the Clause 6 of the Assam Accord, which aims to create a very specialized set of citizens within Assam who have exclusive political, social, and economic rights over the other set of citizens, right? So the other set of citizens are not really non-citizens, but I would say they're half citizens, they're midway citizens, where they're people of Assam, but they're not entitled to the benefits that quote unquote the Assamese, the core Assamese or indigenous quote unquote indigenous Assamese people will have. So essentially, this entire affair has a lot of quote unquotes, which essentially means that there's a graded level of citizenship, liminality that has been created through these processes.
And if I can just add to that, I mean, this is again, you find this type of idea that it's the responsibility of the individual whose citizenship is suspected to provide the evidence and the proof to establish that they are citizens. And often the types of evidence that they are required to provide are documents which the government is obligated to provide to them. So a birth certificate, for example. And it's the historical failings of the state to provide people with those documents, which then is used to justify their exclusion on the basis of that lack of documents, which is just another level of dystopian. And I mean, you find this in Kenya, for example, vetting committees set up to scrutinize the citizenship of members of the Nubian community. Or, I mean, I can give many examples of countries around the world. And just one final point on that, there's very clear international standard that in determining whether someone's a citizen or not, that at the very least, the burden of proof needs to be shared between the state and the individual. And the state has an obligation to use its powers and its the whole bureaucracy behind it to investigate whether someone is a citizen or not. And that clearly isn't happening in India, and we know why.
Thank you, Ahmad. Yeah, I mean, as you say, the burden sharing of documentation, and the government is supposed to issue documentation, and then it fails to issue documentation, and then that is held against the citizens as their as being illegal migrants. As one of the important things that Anjuman had made in her in her presentation is that children don't have birth certificates, and she said that if a birth certificate is obtained after 3 months of the birth, then that the courts don't don't admit that as proof of birth. I don't know, I mean, this is something that I've heard new, but this is crazy. And in fact, we have seen that children, so people in Assam now have become particularly careful to get documentation. A lot of children who are born in the last couple of years have birth certificates, but above 3 years old children don't have birth certificates. Aman, you want to say something on that?
There's a provision actually in the registration of death and birth, I think section 13, which says that if you register the birth after 1 year of birth, then you will have to take a special permission from the judicial magistrate, not from the executive magistrate, local executive magistrate. And if that permission is not taken, then it is not a valid document. So if it is not a valid document, it is not the tribunals, or even this happened during the NRC also, because a large number of women and children are out of NRC list. And one reason for women, we know that they have very weak documentation, considering they get married before turning 18, which is minimum age to vote. So they don't have documents. The same goes with children. The only document for them was birth certificate and board certificate, which very few people have. There is a huge dropout rate, but only in the fag end of the NRC. It is during the claims and objection when government submitted a SOP where it said that if the parent gives an affidavit stating that XY is my XYZ is my child, then their name will automatically come in the NRC, and that's how a lot of children saved. But then this happened only in the fag end in 2019, 2019 or 2018. But all these years, there are people. The first suicide that happened in Goalpara happened because of not because of the fathers, the persons who died because of his documentation, but because of his daughter, I guess, his daughter's documentation. So these are the problem. I mean, after now it has become quite popular, but before NRC process, it was not very popular. The registering birth and all, and with the improved health infrastructure, people are going to hospital to for childbirth. But then this is only in the mainland. In the chore areas and all, there are hardly any there is no hospital actually. Where do they go? Apparently, some 2 million people resides in the chore area. Where do they go? I mean, so even today, these people are. I mean, if you take birth in the hospital, you get a certificate, and then you can register your birth. But then people who don't have access to health infrastructure, now, for them, it is unthinkable to get even their birth registered. Although it has become quite popular now, despite that, a lot of people are being deprived of it. So this entire documentation regime, that if you give XYZ document, you can prove your citizenship. Which documentation may not be foolproof in all cases. You cannot just depend on documentation and then decide their citizenship. So this is what happens. This worst humanitarian crisis of our times, which is going on, and that's how more people are becoming stateless. So that is what, and to just to add that, the question that you say that what can we do now? Of course, follow due process. How to follow due process? Well, it is very difficult. But then, what is in our hand right now? This is a systemic problem, as Sanjay sir has said. But within the existing system, what can we do? I think the best thing is legal representation. How to help these people? Even today, I see here in Jorhat, there are hardly any lawyer who can fight FT case properly. In Barpeta, in Bongaigaon, Goalpara, most of the lawyers, they can't even draft written statement. We started this training program in 2018. We distributed these written statement formats and a training manual. I also conducted a few training program with Ravi sir in Bongaigaon. But I think these training programs should be increased. We need to train up, improve the skill of these lawyers, and then try hard to provide, to create access to legal justice, and that is our intent to create Sambidhan Kendras across Assam. Is this, of course we are bridging the gap between the people and the constitution, but these Sambidhan Kendras will also have a legal aid center, which will serve as a kind of emergency ward of the hospital. That this is the need of the people right now. They don't have the access to justice. Where do they go? They go and end up with a lawyer who can't even draft a written statement, who take lots of money. People have to sell their cattle, their residential plot. So I think it is very important that these legal aid centers, either you name it constitution center or not, that is up to you, but this legal aid center should come up. Yeah. Otherwise, it is very difficult for people to go and catch hold of a good lawyers. This has become like sort of pandemic. I mean, everywhere notices are being sent. Generally, that's not how legal problem operates in other part of the country. We talk about our entire jurisprudence on legal aid is for those people who are accused of any crime, and then they should get legal aid. But maybe when this citizenship jurisprudence has not developed till now. Of course, Constitution doesn't say much about it. Citizenship Act says about how to register, how to terminate citizenship. But this entire problem that has created, the so-called adjudication of the cases of citizenship, the problem that has created has not been addressed by any forum. Anshuman mentioned about S.K. Sinha's order, subsequently Sarbandha Sonowal judgment, and then the Assam Sanmalita judgment 2014, by which NRC was the order of NRC came. These are the jurisprudence now, which have justified illegal migration, which has justified external aggression. So the jurisprudence has been reduced to as if there is an invasion, external invasion, which is not true. Which is not true. Even ask me, I have, like, right now I have gone to like almost the majority of the district to fight cases. And in Guwahati, because I stay in Guwahati, I challenge these FT judgments, FT orders. I get cases from all across the state. I have not come across one foreigner, not one. I mean, leave apart me, people like H.R. Chaudhary, who started practice in maybe 1979. I spoke to him, sir, did you come across any foreigner? He used to challenge Quit India order. There used to be Quit India order earlier, before 1985. He said, no, I'm here to come across any foreigner. This entire,
Thank you, Aman.
this entire propaganda is against Indian citizen and not foreigner.
Thank you.
That is the bottom line.
Thank you, Aman. It was, you have taken us through deeper questions. Thank you so much. So we are going to wrap up now. If there is, I hope there are no other questions. So thank you so much. Thanks to all speakers and all the people who have attended. And thanks to Institute of Statelessness on Inclusion for providing us with this logistics of organizing the webinar. Thank you so much. At the Right to Nationality and Citizenship Network, this was our first webinar, but we are hoping to organize more and generate. Basically, the network came together to strengthen the debate and discussion around citizenship issues, and we hope to organize more and bring in more people into the discussion. So I hope everyone who has been here today and those who registered also but could not attend, I hope they will be able to access the video documentation of this webinar. It will be there, I hope, on ISI website, and we'll also put it up on our Facebook, Anshuman, and our website as well.
Yes.
So I hope people, those who registered, will also be able to access the webinar, the video. And yes, and thank you so much to everyone. And I hope all of you will join again in another webinar we'll organize very soon. Thank you so
Thank
much.
you.
It
Thank
was
you.
wonderful. It was wonderful.